All right, so let's move on to this story now. So former Public Protector Busisiwe Mkhwebane, now an EFF MP, remains determined to claim a 10 million rand gratuity. In a recent courtroom saga, the Gauteng High Court Judge Colleen ruled against Mkhwebane's urgent challenge to the gratuity non-payment, holding the Public Protector's Office responsible for delays. The judge's decision ordering punitive costs against the Public Protector of South Africa amplifies Mkhwebane's ongoing legal conflict, now targeting her successor, Collega. The legal challenge unfolds amidst allegations of perjury and financial mismanagement, underscoring Mkhwebane's pursuit of what she contends as rightful entitlements. So joining me now to discuss this is legal analyst Mpumelelo Zikala. Mpumelelo, good morning to you. Thank you so much for joining us. I think this is quite a complex matter and goes back quite a while, particularly when you look at the arguments that have been put forward by the current Public Protector on the bill that she believes Busisiwe Mkhwebane has left the office with. Let's start with that. Do you believe that the arguments put forward by the Public Protector's Office are valid, particularly on the bill that has been left by the former Public Protector?
Good morning to you, and also good morning to the viewers. Well, it would depend as to what was agreed to when the ex-Public Protector, Advocate Mkhwebane, was getting into office. Now, let's differentiate between pension and gratuity. Gratuity is just a token of appreciation to say you've done so well within the office, you've taken us to higher levels. This is our token of appreciation to you. Now, because we're dealing with public funds and public monies, the National Assembly and other committees would have sat down and said, this is what is going to make you qualify for that gratuity, and it's going to be paid under the following conditions. If there's something adverse that has taken place, then this gratuity is not going to be available to you. For a lack of a better word, and loosely explained, it's almost like as a tip to say, in addition to your normal salary, this is the tip that you are given to you. Now, if the current Public Protector then says, you cannot pay this amount of money because we are now left in a position that is much worse than we were in when the ex-Public Protector came into office, then she has to go and find strong legal views and strong terms and conditions which are going to say, I, the accounting officer, have been given a responsibility to look after the coffers of the Public Protector, and I'm doing this because I can see that there are other things and expenses that we have to pay, not incurred by us, incurred by the ex-Public Protector, and we are going to use those funds to set off whatever expenses that we might have. But before she does that, even though it might sound rationally good, there need to be legal points which are going to be there, and something that you can be able to go to court to and say, this is the reason why I've stopped this payment or why I've not authorized the payment to be made.
I wonder just how far Advocate Busisiwe Mkhwebane's argument then goes when she essentially argues that her predecessors have all received that gratuity.
But there's a difference between the two on a factual basis. The previous predecessors were not, for lack of a better word, taken out of office. Their term of office came to an end, and when that office came to an end, then they left, and upon leaving, then they were provided with whatever gratuity was provided to them. So if you look at it from an agreement point of view, I say to you, you must come to work and provide work at the end of your bulletin, then you must leave, and then you do that perfectly. So I must give you that gratuity that I promised you earlier. However, if a person leaves during their term, not because they have resigned, but because there's an order of parliament that says, we have found you incompetent, we have found you to have broken the rules, we have found you to perform in a manner in which a Public Protector ought to perform in, then definitely there might be some arguments and say that you are not entitled to that gratuity, and this is what we are going to use that gratuity for. But where it's going to matter the most is because we are dealing with public funds, there must be enabling legislation or at least a policy which is going to determine under what conditions is that gratuity not going to be paid. If it's not there, then it may be that they have good intentions. However, because they haven't catered for such, then they can't engage in something which has not been catered for in law.
Yeah, and then there's the argument that's put forward just on the legal costs that Mkhwebane really has incurred, right? You've got Galega essentially saying that her office paid 31.1 million rand for the applicant's legal counsel, 380,000 rand to the legal team, 330 for the traveling costs, and 565,000 for protectors. I mean, the success rate that Galega can have with that argument?
Again, it comes back to what was agreed to in the earlier stages. That if you then say, if you live with this office with no expenses which have been incurred by you on a personal basis, and I say personal basis in the official capacity as a Public Protector, then we are going to pay you the gratuity. So you leave this office, there are no things that you've paid for out of our own pockets, which were basically to protect you. In this case, you know that on the last occasion or near to the end, there was expenses that were paid for by the Office of the Public Protector to fund what the parliamentary inquiry which was taking place. Then if we haven't agreed to that, then there's no way in which I have an enabler or something which is going to stop me from paying the gratuity. But if we have agreed and said at the start, I'm going to pay you this gratuity provided that you leave this office peacefully, provided there are no other expenses that you have incurred, only then would those gratuity be paid. But if the expenses that I have incurred, that I need to set off and pay off, then it's only fair that I do not use the public funds to pay for that. Let me use the gratuity which would have been paid to you and offset or pay all those expenses that will be incurred under your name.
Yeah. Mkhwebane essentially wanting Galega hit with punitive costs as well. I mean, it's at a point where we've already seen Busisiwe Mkhwebane hit with personal costs in and of herself. The likelihood that we could see that happen for Galega?
Well, it should depend on how she has handled herself in this matter. The court is very, I wouldn't say skeptical, but it does give out punitive costs under circumstances in which they are saying, you've misbehaved. You knew the law and you ought to have known what the law was supposed to be, and you've engaged in a conduct that is not becoming of a person who's sitting within your position. However, if you then say to the court, all I was doing was to interpret the legislation and other policies which are available to me in this particular manner, I apologize if that was the case, but it was not through any other malicious intentions other than the sole cause of saying that I want to protect the interests of the Office of the Public Protector. I want to ensure that we're on the correct side of the law. Then the court is not going to issue out those punitive costs because they would say, disagreements are going to occur each and every single day. Misinterpretations are going to occur each and every single day. It's one of the reasons why I have a job, by the way. Yeah. So in those instances, we cannot punish a person for holding the abuse, but we are going to punish the individual who intentionally and maliciously engages in conduct which is unbecoming.
Yeah. What are the next steps for Advocate Busisiwe Mkhwebane in your view?
I think she has to wait up until she receives the reasons that have been given or that ought to be given by the Office of the Public Protector as to why. And then she can look through those through a fine comb to say, are they legislatively compliant or legal? Is there any legal compliance to it? Is there any loophole that can be found to say, you do not have any powers of discretion to withhold this gratuity payment? The only thing that you have to do was to simply pay it. I think that's the only thing that she can be able to look at. And if she finds something, then she can go back to court, re-enroll the matter and say, court, I've now received my reasons, and these reasons are incorrect based on the following in the following case law. Can you please come to my aid and order the Office of the Public Protector to pay my gratuity and also to pay my legal costs, as I've had to come here today to be able to argue on something that they ought to have known in the first place.
Yeah.